Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, alibiers, breaking news, crazy news, have mercy. I'm not doing any intro because we are waiting on another hearing to begin in about 40 minutes, but I want to update those of you who are at work and can't watch the hearings, don't know what's going on, but may get your little podcast alert. We're just going to jump in and I'm going to summarize the hearing that was had this morning about Charlie not waiving his Sixth Amendment right. So the first person up is one of his appellate attorneys, Ms. Niles. She puts the court on notice that he does intend to invoke his Sixth Amendment rights. Prosecutor Kappelman says the issue has been waived, and the judge says as to Ms. Adelson, but concerning Charlie, the only way his representation could occur is if both Charlie and Donna waived, but he doesn't think Charlie waived his rights one way or another. The prosecutor says her understanding is that he did, but that position is obviously changing. And she says she defers to Your Honor on that. She says Charlie would be a rebuttal witness at this point. That could change. Meaning what we've heard and the rumblings is that Donna does intend to take the stand in her own defense. They would use Charlie as a rebuttal witness to impeach Donna. So I don't think they're going to release Charlie from testifying at all. It's very important that he remain on that witness list as a rebuttal witness. The judge asked Ms. Niles if there is a reason why Charlie waited until yesterday, and she said that's when the conflict arose. The judge says the conflict is there. It's as clear as my nose. Is there a reason that Charlie did not raise this until yesterday? She said her understanding is Charlie hadn't waived at all, and yesterday they put the parties on notice that he was not. She doesn't think his rights would be infringed on until he took the stand and his former counsel, Dan Rashbaum, or another member of the defense attempts to cross-examine him, or they advance on issues materially adverse to his issues. The potential for conflict was always there, and that conflict will arise on the witness stand. Now, Mr. Morris, defense attorney for Donna, gets up and says that when he came on the case, he knew Rashbaum had represented Charlie, and he knew of the conflict, and as a result, he has been walled off from all discovery from Charlie's case, all the notes Mr. Rashbaum had, and has had no conversations with Rashbaum about Charlie. Charlie asked if Mr. Morris, Donna's attorney, had seen his phone, which Mr. Morris said he had not. He said he personally was going to be the one to conduct cross-exam if Charlie testified, but they plan to retain a third-party counsel. However, there's been no retention as of now in terms of money, but they're prepared to do that, but they wanted to see the judge's ruling this morning. Mr. Morris spoke to that attorney yesterday. The availability and the absence of conflict would need to be looked at. The judge asked if there's a reason they didn't tell the court they were seeking third-party counsel or that there was no waiver with Charlie. And Mr. Morris said there's a written and verbal waiver from Charlie. They had a third-party lawyer who consulted with Charlie independently regarding the waiver, and it was agreed to, and he thinks Charlie's waiver would be verbal. The written part of the waiver would be from the attorney who consulted with Charlie, and that was due to security issues where he was being held, and they could not get a face-to-face conversation with him due to his incarceration. Here's the kicker. A verbal waiver is not going to cut it in this case. It's going to have to be written. Now, the judge says, assuming he finds the walling off has been sufficient, why should Dan Rashbaum's representation not be terminated at this point? And Mr. Moore said the motion Charlie's attorney filed relates to cross-examination, and he understands Charlie's objection is not to Rashbaum's representation of Donna. And the judge says that Donna has the right to effective representation at every critical stage. And he says he won't allow any issues to get backdoored should there need to be an appeal. And he asked, is there any dispute that Mr. Rashbaum doesn't meet the elements to Calker? That's the case that we went over yesterday in the filing, which is a substantially related representation and a client that is now asserting a non-waiver of conflict. Mr. Morris said this has been a known circumstance from the inception, and the judge says, yeah, it has. Mr. Morris said it cuts both ways. He has no qualms that these circumstances should be avoided, but beyond that, Charlie can change his mind at any time. The judge says, well, Ms. Niles' appearance here is an indication Charlie has changed his mind. Morris says the conflict is Charlie doesn't want the cross-exam to be conducted by any member of Donna's defense. Now, Charlie's attorney says their filing had concern about potential sharing of information within the defense team. He was not waiving his privileged communications with Rashbaum. And after they read the defense's response last night, it would not be enough to have a walled-off attorney, meaning Mr. Morris, conduct the cross-exam. She cites case law that you cannot use information to the disadvantage of a former client, and you could not advance an interest that is materially adverse to a former client on a substantially related manner. His attorney goes on to say whether we have another attorney do the cross, it still doesn't satisfy case law. A third party to cross-examine Charlie doesn't resolve the conflict. It's the relationship that forms the basis of the conflict, not just the information. Mr. Rashbaum cannot advance an interest against Charlie because he is now going to be a witness for the state. That is a problem under Florida case law as well as Florida bar. Defense attorney Morris says Donna has a right to counsel of her choice, but the judge says that is not absolute. Mr. Morris says Charlie may not testify, and that's the frustrating part. This can be utilized as a tactic in some respects, and the judge says it doesn't mean Charlie still can't lob a hand grenade in the direction of the trial. Mr. Morris says the defense does not intend to call Charlie, and he says the state said they would call him in rebuttal if they were to call him, and he can't fathom why there would be a lot of cross-exam. The judge says if Charlie can't be properly cross-examined, Donna has lost the right to effective representation, and we have an issue if a new trial is merited, and he says it's foolish to charge forward. He says he can question Donna, and she can waive the issue of conflict and waive the issue on appeal, but it still doesn't resolve the matter. So Donna gets up and raises her hand, says she understands she has the right to conflict-free counsel, and her attorney has to be able to cross-examine her son if he's called as a witness. She understands all this, and the judge asked, do you understand how this conflict affects the cross-exam or her overall defense strategy? He also asked if she's spoken with a conflict-free attorney about this, and she says no. She would like to speak to conflict-free counsel. We are in recess until 10:30. Now, the jury pool from this morning was sent home. They'll be back at 10:30, and we should know one way or another what to expect after this hearing. There is another jury pool that is set to come in at 1:15. I don't think it's going to go forward. I have a big gut feeling that either Charlie has to waive this or Donna is going to have to get an entire new defense team. And that is going to delay this trial. A whole new defense team. It's going to take months and months to get up to speed on where we're at and also to form defense strategy with Donna. So that is the latest that we know. I will do another update episode after this 10:30 hearing to let you know what was said. All right, guys, we'll see you